Hi, this is CPA Ted Lanzaro, and welcome to today's Forensic Accounting and Investigative Services Divorce Podcast. Today we are speaking with attorneys Veronica Reich and Michelle Zulawski. Today we're going to be talking about how we can help the spouse that's financially dependent and maybe starting a divorce process and really doesn't know what to do. So that's what we're going to talk about today. So Veronica, can you introduce yourself to our listeners, please?
Sure. Thank you for having us. My name is Veronica Reich. I've been practicing law now for about 40 years almost, and almost all of it has been in the area of matrimonial litigation, divorce law. I live in Stamford. I'm the mother of 2 adult children and proud grandmother of 2 children. So that's given me a lot of experience in how families work and how they don't work. I work with men and women and often with children about equally. In Connecticut, if there's a contested custody case, the children get their own representation as a guardian ad litem or as an attorney for the child. That's really more in custody areas, but I have experience representing all kinds of people in divorce actions.
Great. Michelle?
Yes, hi. So I have been practicing for about 6 years. I've worked under Veronica's guidance for about 4, working specifically with the family law section. I've actually clerked in the family courts when I was right out of law school, so that was my first exposure to it. And I really enjoy staying in this niche and becoming an expert again behind Veronica and working with a lot of the great attorneys in our office. I attended Quinnipiac University School of Law, and I live in Milford, building a home there, and I'm really happy to be part of our firm.
Well, that's wonderful, and thank you guys for that. So, as you know, I'm a forensic accountant, and so I almost never get a call for a friendly divorce. Every call I get is typically contested, and typically I'm dealing with the financially dependent spouse, the one who earns less money, and they're sometimes about to be the victims of a potential fraud. So let's start with just some of the mechanics of divorce. So I'm thinking I'm that spouse. I'm thinking about divorcing my spouse, and I know that it's going to be difficult because they're the major breadwinner in the house. How do I even get started with that process?
Well, I think the first step would be to have what I call an initial consultation. It's really an educational session, about an hour to 2 hours, depending on the complexity of the issues. I ask people to fill me in on the facts. I will fill them in on the law. And then we have a very broad discussion about the spouse's rights, the spouse's responsibilities, the spouse's obligations, and the same for the other spouse, and what the whole matter might cost in terms of time and money and effort, and some kind of reasonable parameters about where the case would go. In that initial session, we also tell them what kind of information gathering that we need. And that's a very important first step. The legal term is discovery, which is just a fancy term for gathering information. And there are a lot of ways to do it, but especially for the spouse who has been more financially dependent and often not aware of the financial circumstances of the marriage, that step is very important.
All right. Yeah, no, that sounds great. And those are primarily the people that I'm dealing with. So let's just get into a little bit of the mechanical, the law kind of stuff. So how does alimony work in the state of Connecticut?
Yep, I'll take this one.
Yeah.
So alimony, it's obviously dependent on the significant assets that are tied between the parties. There's many factors that are taken into consideration, and one of those is length of the marriage. We focus on health of the parties. Amount and sources of income obviously is a great one. The earning capacity, one may have a career and one, as we've talked about, may not work outside of the home. occupation, vocational skills, if that party's employable or not. Needs and station in life is another. Needs and caretaking of any minor children that may be in the family. And then causes of the dissolution of the marriage. Connecticut is a no-fault state, but that can be taken into consideration when determining an alimony order.
Just to elaborate a little further, in Connecticut, there are no guidelines. There's no hard and fast rule about alimony. There's nothing mathematical or formulaic about it necessarily. I mean, we're more and more dependent on computer models, but the legal idea behind alimony is to look at all of the financial factors that Michelle mentioned and try and determine something that will work for both parties. And it's sort of a, art more than science, because you have to look at all those subjective factors that she mentioned. Like, for instance, station in life. You consider station in life. What does that mean? It means essentially lifestyle issues. How the parties lived as a couple or as a family could be one factor in determining how they might live as individuals. And Michelle mentioned that we are a no-fault state, and that is absolutely correct. But what that means is that you don't need to prove fault, who did what to whom, to get a divorce. However, if the case gets really ugly and it is tried to a judge, then a judge is allowed to consider the issues in the marriage about what happened, who did what to whom that really led to the breakdown. But that's only in the most contested cases. Usually the most important factors are the financial ones. You also have to remember what alimony means. People aren't really sure. The definition is essentially it's a continuing duty to support. So you have to figure out what is the continuing duty of one spouse to continue to support the other when they're no longer spouses.
Gotcha. No, and that those are some really good points. And so I think child support is more mathematical. That's correct? Right. So we explain how that works. How does child support work? Because some of these people that are going to be looking to this as a resource are going to have young children, and so how might that work?
So there's actual mathematical guidelines. Typically, we are actually often using a computer program to calculate that for us. Years ago, people may have done it longhand with the form, but we enter that information and you get the combined net income of the parties on a weekly basis. And then that determines what one presumptive amount would be for one party to pay the other. There's also a cap on the guidelines up to $4,000. But you can go above and beyond that. That's typically by the discretion of the court if one party would be awarded more above that amount. Those guidelines also calculate the uninsured and unreimbursed medical expenses that parties would share, as well as daycare expenses. That's about all.
We should talk about that cap for a minute. When we say there's a cap on child support, the calculation is actually mathematical and formulaic. You put in one party's income, you put in the other party's income, you work through the magic of the guidelines, and you come out with a number that is the presumption that one party should pay to the other. It's based on joint net disposable income to both parties. If that number is above 4,000, and keep in mind that's both parties' income, and keep in mind that it is net after taxes and other reasonable deductions. If that amount is over 4,000, then the judge has discretion in how much child support to award in the event that they have more joint disposable income, more than $4,000. But yeah, it is mathematical.
Okay.
we are supposed to consider other factors sometimes, but 99 times out of 100, they look at the guidelines and that's the number.
And does that model take into account that the children may be living in one house 5 days a week and the other house 2 days a week, or how does that, or you have 6 kids literally?
Well, there are some additional provisions in our child support guidelines. There is a provision for split custody. Sometimes one parent will have 3 kids in your example, and the other parent will have 3 kids. The way the formula works is essentially to figure out the child support for each side and then make a deduction to make it clear that one person, usually the one that has more income, will pay something to the other, but it acknowledges the fact that the higher earning parent also has the child expenses because 3 of them live with that parent. And so there's a different calculation for that, and it's spelled out in our guidelines. What you mentioned, however, is a really important hot button issue, the amount of time that a parent spends with a child. And for the most part, our guidelines do not take that into consideration. They don't. Usually we have someone who has the kids more than the other. Sometimes we have situations where they share equally in parenting time. The guidelines do not really provide for that, except they do allow for some deviation, but only limited by what's in those guidelines. What that means is, if you have a situation where the parents have pretty much equal time, you can deviate from those guidelines to some extent.
Gotcha. Okay. So that was pretty good. That was pretty clear. And I think it really explains the topic. So the other part of a divorce is the asset division. How does that typically work?
So assets, typically we put them all into the marital pot. They're all combined. Again, there's similar factors like we just talked about with alimony that determine how those assets are divided. Again, it's a no-fault state, so property division is, not dependent upon fault of one party or the other. Some people are also under the misconception that if you are married for a long time or even a short amount of time, that assets are split 50-50, and that's not just always how it falls. I think that's, aside from the factors we already listed without being repetitious.
That's absolutely correct. To determine the division of the assets, although there's often a default to 50-50, the law does not state 50-50. The law does not say that there's an equal distribution. The law does say that there's an equitable distribution, and that's different from equal. It means what's fair and what's reasonable. And how do you determine what's fair and reasonable? You look back to those same criteria that are used to determine alimony, the ones that Michelle referred to earlier. Age of the parties, health of the parties, their employment opportunities, plus one other additional factor beyond the ones that are considered for alimony. And that is, I'm going to obviously quote the law, the contribution of each of the parties in the acquisition, contribution, and appreciation of their respective estates. So what does that mean? Michelle mentioned that everything's in the pot. That is absolutely correct. Everything's in the pot. No matter how acquired or when acquired, your inheritance that you've received. Grandma's dishes, the family dog, the estate in the Hamptons, the IRAs, the pension benefits, the credit card debt, the student loans, everything is in the pot and subject to equitable distribution by the courts. And the court can consider where it came from. Like I had it years before we got married. It's a premarital asset. It shouldn't be divided. That may be the case, but it may be considered. Every asset and every liability can be considered in equitable or fair distribution. Yes, there's often a default to the 50-50 split, but that's not what the law says, and that's not how it has to be.
Okay. So a lot of the people, at least the ones that I talk to and the ones we're sort of aiming this at, I'm going to pick up the phone. It rings, the phone rings, I pick up the phone, and, I'm talking to someone and they say, look, my spouse is the primary breadwinner. I was the stay-at-home spouse. They make a ton of money. I'm financially dependent on them. My spouse is a controlling, lying, abusive person who told me they're not going to give me a dime, and I know we're all familiar with this story. So, my spouse is not going to settle. He's not going to, or he or she is not going to mediate. What does going to trial with somebody like this, what is that going to entail?
Well,
yeah,
I mean,
a lot of discovery.
Yeah, trial, obviously, a lot of the discovery, a lot of the gathering of the information that financially dependent spouse would not have access to. And it's stressful, it's time consuming, it's expensive. There's no guarantee as to what way the outcome will fall. It's definitely a risk to go. Throughout the entire process, our goal is always to resolve the dispute and not proceed to a trial phase. But again, it depends on both sides and the amicability or lack thereof. But we do strenuously try to reach that result before proceeding to trial. We may even resolve it on the court steps on that day. That has happened before. People will be very gung-ho about going to trial, and then when you get there, everyone's nerves tense up, and then you want to resolve it to save, again, the time, the money, the stress, the aggravation. It's emotionally taxing on the parties, both of them. But again, yeah, it's not a guarantee, so it's risky.
And also, you end up in a trial really airing all your dirty laundry. And the parties essentially have to mix my metaphors, sling mud at one another because they want the court to think the other person is really horrible and bad and to give them a financial tip because of that. And they can do that in a trial. But especially when there are children, these people will have to some extent live with each other on some level for the rest of their lives. And to live in a constant state of war when you've kind of declared war by going to trial is a very difficult thing. And before you get to that point, you really need to exhaust every opportunity in terms of finding those hidden assets. Mm-hmm. Tax returns are a wonderful way to look at that and find things out. We can demand production of bank statements and credit card statements and any other kind of financial document, even letters, things like that. And everybody says, my spouse isn't going to cooperate, won't give me anything. We can force it. It could be expensive and it could take time, but people have to give up the documents. Sometimes we have to hire experts, like a forensic accountant or a business appraiser, or we've even used on occasion asset search firms that look for assets nationally or even internationally. So it's a long process, but it's one where you have to be thorough because, once a divorce judgment enters, you can modify some things, but you can't modify a property settlement. And you need to be sure that you have all the assets and all the liabilities accounted for. You might take depositions, which is essentially just formal testimony under informal circumstances, but it is under oath. So I'm sure you've been deposed before because people want to, know exactly what the expert's going to say ahead of time. And that also helps settle the case.
And
Yeah.
it's important to note the trial process too, it involves a lot of the preparation ahead of time. We have to work with the parties and or other witnesses that may come to the trial. And testifying is not something that's natural to a lot of these clients. And that is something that scares them. And we really have to teach them how to answer the question that's asked, not give too much information, be very simple and concise, keep the emotion behind them. So again, that also goes into the trial. It's not something that you just show up that day and hope for the best. It's detailed.
Yeah. And I've heard that my spouse is not going to provide me with any of the paperwork, kind of story. And that's typical. That's the one that I'm probably used to dealing with the most. And so, how do you go about compelling them to give the information? What's the process of, just compelling discovery if they literally just refuse it? And I'm sure, and I've seen it, and I'm sure you've been on the other side, where the opposing counsel is using, withholding discovery as a tactic to just stall the whole thing.
Yeah, it's really unethical, but you're right. It happens a lot. I think the first step is just filing your discovery request, and you have to make it as thorough and specific as possible. Our law gives you a certain period of time, usually now it's 60 days, to respond. If they don't respond, they can also object, and they might object to something, but then there's a process for resolving those objections. But if you get no cooperation and they just don't, we file a motion to compel the discovery, which gets on the calendar, and they show up, and they better explain really clearly why they're not providing anything, like the house burned down or something. But other than that, there's really no reason not to. And people have been sanctioned, both parties and attorneys, for not cooperating with discovery. So it takes a while and it's not easy, but the court can enforce it by by sanctions, by attorney's fees, and on very rare occasion, even by incarceration.
Gotcha. Can you guys subpoena documents from like banks and employers and that sort of thing? How does that work?
We can certainly do that, and we would serve a subpoena on that corporation or entity, and we would ask for the laundry list of the documents that we're seeking, and we can have them either come to a deposition for that discovery, or we can ask them to come to court for a hearing or a trial for that discovery, and we can release them from the subpoena if they do provide it in advance, which is always our goal. We ask them to comply by a particular date so that everyone has what they need without, rushing towards the end and having that information last minute before we do show up to the deposition or to court.
Great. So let me run a couple of typical scenarios that I run into as a forensic accountant all the time. These are the things I kind of hear. My spouse is hiding money. His family is helping him. He works in his family business. My husband is, my spouse is hiding his income or her income. The family is helping, a whole bunch of different scenarios. How do we go about handling something like that?
Well, most people don't realize that there is pretty much a paper trail to most things. And if I really think there is that kind of activity going on, or if there's just a business and I don't have a handle on what its value is, or if it's a cash business or what kind of income it's really producing, I would hire someone like you, and you would go through their books and with a fine-tooth comb. And a good forensic accountant will be able to see. And you even go to the store or business or whatever it is to see what's going on, to really try and flesh out the reality and find the facts. If family is helping, then we can depose family members and warn them that, lying under oath in a deposition is perjury. And it is punishable by law. Now, Does that happen often? No, it doesn't, but very often it's a potent threat. And we can gather the documents from various companies or banks or corporations, as Michelle indicated. But it's a long process. It's like unraveling a scarf. You pull one thread, and then other things seem to just come from it. You know what I mean? Until you're left with a very long thread, and you're able to see, you know, where each piece of the puzzle falls.
Yeah, I think you just described my business. You know, right? That's typically what I'm doing. I never thought of it about like that, but that's the whole. And you know, typically it's funny because a lot of the people that I talk to, they say, "Oh, my spouse is financially sophisticated, and my spouse is so smart." And you know, I've never met one that was smart enough that I wasn't able to figure out what they were doing.
There you go. You know, I mean, you have to take into consideration that the dependent spouse is probably really afraid and really has a very low knowledge base. I mean, we've represented some spouses that never wrote a check, lived his or her life by a credit card, and the other spouse paid the bills, and they have no idea what where the income comes from or what their assets are, or more importantly, what the passwords are to any account. And that's really critical because a lot of people function now on the computer. And we have subpoenaed QuickBooks records. And we get them to an expert, and you find out what you need to find out in order to really get a handle on both the assets and the income. Great.
How about, you know, I'm sure you've run into the situation where the spouse is actually afraid of their other spouse from either an emotional or physical violence standpoint, that kind of abuse. You know, tell us how you would handle something like that just in working with that person.
So if there is actually a fear for your life or the safety of your children, a restraining order can be filed, and we've certainly had cases with that. And then again, you have to go to the hearing level to see if that would be granted and for how long that would last, possibly about 6 months. And then if we are in court, you know, some parties, whether there's a restraining order or not, don't want to be in the same room or the same setting, even a deposition with that other party. It's an actual emotional fear for that person, and it affects them on a stress level to even function throughout this process. And it's disheartening to see, but it does happen in a lot of cases.
Yeah.
We try and provide as much support as we can, but we're lawyers, we're not therapists. And sometimes we feel like
we really are.
Yeah, but we're not trained as therapists, except by experience maybe.
Right.
But I encourage people to get support, perhaps from family, perhaps from a counselor. And if someone is genuinely fearful that a spouse is going to explode or really cause a problem, I always tell my clients, your safety and that of your children comes first. So if you feel a threat, then you have to address it. Either call the police or tell us to get a restraining order. But we don't ignore those situations. You know, 99 out of 100 are fine. And then you have that one that explodes, and no one wants to be there for that.
Right. Yeah, no, I totally get that. I think that's a you know, a really good point. And it's very hard to function if you're worried about your safety, you know. And you made a great point about counseling and stuff. I think that's important. And I act as a sort of unlicensed therapist sometimes for my clients too, and in most cases more like a cheerleader, and say, hey, you can do it, you can get through it. You know, I'm sure you guys do that. So what kind of documents should, if I'm the financially dependent spouse, what kind of documents should I be putting together? What should I expect just to have to put together myself?
So, I mean, if that person doesn't have access to a lot of the actual financial documents, then that's what we would do through the mandatory discovery process for that person. But we also always ask our clients to create a journal of certain dates, events, things that may happen over time. Again, this process could last up to a year, even beyond that, and courts don't like it, but it does happen. So we ask them to journal entry certain things. Any documents that they might find within the house that their other spouse may have, under lock and key, that's fair game. That's, in the home, and they can bring us that. Any letters, any other evidence of that particular party's bad behaviors that can, help us out with credibility later on in the trial. What else? We also have to prepare a financial affidavit for that party, and that is one of the most dreadful processes that people go through, because that is the most detailed evidence of all of your income, assets, debts, other property, and people may forget what they've acquired over a 30-year, 40-year marriage. So that's certainly something that each party works on.
Michelle mentioned the mandatory disclosure. It's just a list of documents that if you ask them of your spouse, the spouse must provide them. But if you get them, you also have to give them. The idea is that everybody has a full set of everything. It includes at least 3 years of tax returns for each party. Usually they file jointly, but not always. It includes 24 months of bank statements on every account that you have. It includes recent credit card bills. It includes statements about IRAs and 401ks and pensions. And we give our clients at that first meeting the list. And we tell them, to the extent that you can, gather this information. You're going to need it later. There's also a new thing that's come into play in the last 10 years. You would not believe how much people put on Facebook and on Instagram and on generally social media that is not protected. And we tell our clients, put nothing on Facebook or Instagram. Make sure you change the password on your email so that it's secure. And those are often very fruitful ways to get information, just to look at what's public.
Great. No, that's a great tip. And you know what? I mean, there's a lot of people put way too much information on social media. In this situation where this one spouse is hiding either income or assets, and there has to be extra work done by yourselves, by someone like myself, a forensic accountant, how do we get the spouse that is causing this problem to potentially pay for those services? Because that's one of the things that I hear a lot of is, well, how am I going to afford this? It's not my fault. My spouse is being difficult. If he was just he or she was just fair with me, then I wouldn't have to do this. So I know there is some sort of mechanism that sometimes a judge will order court fees, professional fees to be paid. Tell me a little bit about how that works.
Okay, so if this is something that was in your judgment, if this is a post-judgment matter and this party realized that there was some fraud after the fact with, say, a financial affidavit or an asset was discovered later on, in the judgment, you typically put in a provision that for any breach of this contract, essentially, that other party would be held to pay for reasonable attorney's fees for this party. There is, again, no guarantee that the party seeking it would attain those attorney's fees, but we of course try. We would file a motion for attorney's fees after the fact. And again, if they do have to pay for an expert, that's an expense that they never anticipated. And it's something that can be very, very costly, and it can go on for months until the post-judgment matter is resolved or comes to a conclusion. So we can try, but again, no guarantee, but it should always be in every judgment so that you do have that as a backup should it come to it.
Okay. I agree with that. And also, before judgment enters, when you're doing all this discovery and the use of experts, usually, especially when there's a big disparity, if the more financially independent, the moneyed spouse has assets and the other one is perhaps a full-time homemaker, we get lots of pendente lite during the pendency of litigation, temporary, motions for attorney's fees and expert fees. Now, that does mean going to court. And it does mean both parties filling out financial affidavits. But if it's very obvious that one spouse is controlling everything, then the court will order that spouse, assuming there are enough funds, to pay the other's attorney's fees and expert fees. Usually it comes out in the wash at the end, but I'm involved in a case like that right now, and we've gone back to court 2 or 3 times with motions filed by the other side asking for my client to pay attorney's fees and expert fees to the tune of hundreds of thousands of dollars. And she's gotten them. The other spouse has gotten them because my client has sufficient funds to do so. So it means another trip to court. And if the spouse being ordered to pay doesn't, a motion for contempt will come down the pike very quickly. And the courts take that very seriously, and they have to. If we cannot promote respect for orders of the court, then we just may as well, shut down the courthouse. We have to take them seriously, and they have to be respected, and they have to be enforced. And that really applies across the board.
That's great. Can you explain that, the term used, pendente lite, for the listeners?
It's a Latin term meaning during the pendency of litigation, while litigation is going on. Temporary orders. That's really all it means. But we are under an obligation to label them as pendente lite if it is in them before a judgment is entered.
Okay, and that would be like a before judgment order for the financially independent spouse to pay the financially dependent spouse dollars during the trial in order to be able to support themselves. That's sort of the idea, correct?
Well, yes. I mean, there are many pendente lite or temporary motions. There's temporary alimony. You don't have to wait till the end to get it. There's temporary child support. There are temporary motion for attorney's fees and expert fees. So all these things can be brought to the court's attention while the case is going on.
All right, great. Yeah, I wanted to get that point out because I thought it was very important. How important is it to hire an attorney who works in a court quite often? Does that matter? Does it help?
I think it can certainly help. There's also the advantage of knowing the judges and how they operate. And that's important because you can't always choose what judge you're in front of. Well, you never can, but you can say, look, we have the option of A, B, or C, and I feel really good if we get before A and B, but C, that one can really be a crapshoot, or we're not really sure how that's going to work to your favor. Some judges we found are, more father oriented, and some are more mother oriented. So having an attorney in court helps, but then there are also attorneys who work in offices just as much and then have that experience of more of that discovery background or more of the preparation and really have more of a handle of the case if they're not so busy in court. It's very important for your attorney to be available. Sometimes you may choose an attorney who can't fit your need in that way, and they're off to court so much that you're constantly calling their office and only getting the secretary. So that's not the type of service that you want either. And you really should pick an attorney who matches your personality, your style, the level of effort you're seeking, whether you want this case to go aggressively or you just want it to be a more peaceful interaction. Yeah.
Okay, great. No, that's a great answer. So to finish up, I want to talk a little bit about custody and stuff, and just so I'll give you an example. Sometimes I get my teenage kids hate my spouse. Are they going to be required to go there? What would you answer to that?
Well, there is the answer according to law, and then there are practical realities. Generally, if the parents can't agree on where the children will live primarily or how they go back and forth, or the amount of time that the child or children will spend with that parent, then there are a number of things that can happen. You might get, again, an expert, a psychologist, to do an evaluation and tell us who might be a better full-time parent, or the ability of each of the parents to work with the other, to co-parent. Sometimes one is just really angry and wants to close the door, and I don't want to talk to my former spouse again. That's a particularly bad way to raise children. There are avenues in the Family Relations Department of the Superior Court to assist people in both doing some evaluations and in working through their issues temporarily. Family relations are not lawyers. They're trained in social services. Many of them are social workers, but they work in the courthouse, and they can very often assist in working out issues of custody. Alienation of children is a really important issue now, where one parent accuses the other of alienating the child, of promoting a bad relationship between them. Very difficult to deal with, difficult to prove, and that usually requires experts and therapists, and we work with many of them. The law says that until they're 18, they're minors. They don't get to decide. So a parent has the obligation to encourage their children, again, to comply with the court orders and go see your mom or your dad on the weekend, because that's what the court orders say. You do it in a way where you try to make it positive. Look, no matter what fights you've had, your parent loves you, and I know you'll have a good time, and I'll see you in a day or two. You have to be encouraging and supportive. On the other hand, kids that are 16 or so, or even sometimes younger, will very much have a mind of his or her own. And no one is going to suggest that you hog tie a kid who's screaming and yelling and throw him in the back of a car. I'd rather defend someone on a motion for contempt in that situation for not allowing visitation, rather than, really damaging a kid psychologically or emotionally. But a court will also say when a kid is 15, 16, and again, depending on the kid, sometimes younger, if there's a reason that they really don't want to go, it's very hard to make a court enforce that kind of an order, just because kids often make decisions based on who has a bigger flat screen TV, or, who lets them eat more pizza. The bottom line is, someone very wise once said to me, do you know the one factor that will tell you how well children do after divorce? There is one overarching factor that allows you to predict how well the kids will do. And it's not how many nights they spend with a parent, and it's not whether they go on vacation, and it's not whether they drive them to school. It's the level of acrimony between the parents. If the parents can manage to put their own emotional needs behind those of their children, and have a minimum level of respect for the other spouse, the kids will do okay. When parents are in court and they're fighting all the time, the kids end up knowing, even if you don't tell them. And you have to think about the memories those kids will have. I've been representing children as young as 1 or 2, and the parents are fighting and then are in court every month for years. That child will have no memories of childhood that does not include fighting between the two most important people in that child's life. So I tell people all the time, you have got to foster a relationship with the other parent. But if I have the parent of a 16-year-old who just won't go, I tell them, get some therapy, family therapy if possible, but don't fight it in court, because it's a loser.
Yeah. How about the opposite scenario where one spouse just like says to the other, "Well, I don't want to see the kids anymore. They're all yours." What do you do with something like that?
Well, I actually haven't ever had a case like that yet, but it could come, I suppose. So in that case, if the parties agree that that one parent can have the child because this parent is expressing, no desire to have parenting time, then that works in his or her favor. It's very easy to draft a parenting plan where that parent will take on more of the time. And then again, financial orders may be modified for something such as that with the shift in the time. But yeah, I haven't experienced that yet, and it actually would be a breath of fresh air.
Well, yeah, I actually have, and it's kind of a sad thing because the message to the kids is a very bad one. But I have had a case where one parent, it happened to be the mother, was unable to stay in Lower Fairfield County. She couldn't earn a living, she couldn't afford it, alimony expired, and she had to move out of state where she thought she could get a job and have family support. And the kids wanted to stay in their schools and they wanted to stay with dad. They didn't want to move. So she left. And the father in that case had full, sole legal and physical custody. So it does happen. It's very rare. But you always hope that there is another parent that will pick up the slack, or some other family member, something like that.
Great. So, what is, as a final question to round this out, what would be some great advice for a spouse who knows they're gonna be in a contentious thing? There is going to be no collaborative divorce, no mediation. They already know the personality of their spouse is going to be that person is going to fight tooth and nail.
Okay, number one, save some money. Number two, try and have your own account. There's nothing wrong while you're married to opening your own account. I think each party needs to have a little bit of money of his or her own, because you're probably going to use it up. I would say prepare. Be aware of what you need to find. Gather all those documents, the tax returns, the bank statements, the credit card statements. Let your attorney figure out what's relevant or not, but gather up as much as you can. And I like to tell people to assert as much control over the money as you can. That doesn't mean exclude the other party. It's usually for the less financially independent spouse, because usually they have no control over anything. So get your own money, look at the bills every month, know how much it costs to run the household, know what the bills are, know what the mortgage payment is, know how much you owe. On the mortgage, you'd be amazed how many people can tell you what the mortgage payment is, and they have no idea how much they owe on the house, because you need that number to figure out the real value of the house, what the equity is. So prepare, stay calm, be sure you have some support, and find a good attorney.
Awesome. Ladies, thank you so much for all that information today. I really appreciate it. And, thanks. I can't tell you how much this is going to mean to our listeners.